Phil Bowen. I'm director of the Centre for Justice Innovation, a not-for-profit that seeks to build a justice system which every citizen believes is fair and effective. This research and this seminar have been generously funded by our partners, the Aberdeen Financial Fairness Trust, which funds research, policy work and campaigning activities to tackle financial problems and improve the living standards of people on low to middle incomes in the United Kingdom. So thanks to them for their funding of what is the first stage of this work. So the first stage being the research report out this morning. The second stage will be looking into detailed policy and practice solutions to some of the problems that we've identified. I also want, while I'm giving thanks to people, wanted to thank at the outset members of our advisory board for this project who've helped shape today's report and who I know will play a crucial role in the second stage of that work. And a particular thanks to our trustee, Robert Zara, who has been chair of that advisory board. Before we get into the event, I'd just obviously like to go over some housekeeping. Looks like all your mics, I think we've turned your mics and your cameras off anyway, but if you keep them like that so they just don't disrupt the speakers. And obviously, as you've already seen, we're recording this session. It will be available later online. As we move through the event, please feel free to pop your questions into the Q&A section of Teams and not the chat as the seminar proceeds. And if you have any particular questions, please also make clear in your Q&A section if it's directed at any one of the speakers that we have today. And obviously put your hands up if you've got any technical issues, but hopefully you won't. So today's seminar comes at a difficult time for many of us. The ongoing cost of living crisis has taken its toll on many people's ability to get by and on people's collective mental health. And recent research has suggested over a quarter of adults in the UK are currently feeling unable to cope. This research suggests that some of those people dealing with debt, behind on their bills, means that they don't pay their TV license on time, possibly try to get away with not paying their bus fare and end up with fines in the criminal court. And so our report out today looks at the criminal court fine in the round, but has this specific focus on the experience and impact of fines on people who are already struggling. Alongside the main report that we released today, we've also published a literature review on the evidence on criminal court fines and a data review of all the publicly available data on court fines. So today we will hear from my colleagues Lucy Slade and Stephen Whitehead, authors of the report, and then we will hear from our expert guests, Val Castell, chair of the Adult Court Committee of the Magistrates Association. I'm sure many people will know the Magistrates Association, which is the membership body and independent voice for magistrates in England and Wales. And then we're also delighted to have Damon Gibbons, Chief Executive of the Centre for Responsible Credit, which is a registered charity working to influence the regulation of credit markets, to improve the way that credit is provided and to create better support and solutions for people who are struggling with debt. And we will get their unique perspectives on the challenges posed by the use of court fines for people on low incomes. I will then ask the authors and Val and Damon to be on our expert panel, on which there'll be a chance for you, the audience, to ask any questions that you have. So before I hand it over to our speakers, I wanted to firstly tell you James's story. So as part of our research, we have interviewed 56 people on low incomes who received criminal court fines. James was someone we identified through our community advice service at Highbury Corner Magistrates Court. Our community advice service is an advice, information and support service which acts as a signposting and referral service, putting people in touch with organisations and agencies that can provide them with support. Now, James is not his real name, but James was really keen to have his story told in a way which would not identify him, but which would shine a light on how people experience fines at the moment. So I will ask my colleague Miranda to share his video and share his story with us now.
So I was sentenced December 2022. It was quite a long hearing. I remember being in court with my head down pretty much throughout the whole hearing. as I knew there was a high possibility that I was going to get a custodial sentence. But I was relieved ultimately. I was given a probation order, a community service order. I was given a fine and a suspended sentence. So what I remember about when the judge was talking to me, addressing me in relation to the fine, all I remember the judge asking me was my ability to pay the fine or something along those lines. And my response would have been, I can pay £50 a week. Well, in fact, the judge may have asked me about my income and employment status, but it would have been just a question. I don't think he really asked me in any detail. And then I certainly wasn't given any kind of expenditure form to fill out. And I don't remember much more about. There wasn't really a huge focus on how to pay the fine, who to pay the fine to, when the fine will start, when's the first date of the fine, was there an end date of the fine, is there a period that I had to pay the fine in between? There was none of that. On the days after the sentence, and perhaps the weeks after the sentence, I began to become a little bit kind of concerned on what am I going to do about this fine, because there literally was zero information on that document I received when leaving court on how to pay the fine. Zero. So yeah, that was a little bit of a worrying period. It was an issue that was, if not addressed, was going to be problematic. I remember speaking to my probation officer and mentioning in one of our appointments that I hadn't paid my fine. I hadn't even started paying my fine. I told her that I was quite concerned, that I was worried about the fact that I hadn't started paying it because I didn't want any repercussions. So during that appointment, she made a couple of phone calls to some professionals that she thought might be able to advise. There was no success with that. She then had a second thought and asked me to pop into Highbury Magistrates Court and look for an organisation based within the court called Community Advice, which I did. I think it was about mid-January when I met Michelle. This was a really good thing. I say that because she made every single phone call she possibly could. I remember that meeting. Michelle and I were probably together for about 45 minutes in that office. It was all negative. We didn't get any further in any of her inquiries. My name, my fine, my existence was void. The system had no idea on who I was. I mean, to be quite honest, I actually remember looking at Michelle when we were coming to the end of our phone calls and our inquiries, and I was, the little sort of like, should we say, the little cheeky character in me. I was like, listen, Michelle, great, thanks for your help, but I'm up 400 quid now. I said, at least I can say that we tried to pay the fine. I realised that if I had allowed that cheeky side of me to manifest and walked away without paying the fine, a year later down the road or 18 months later, it could have possibly caught up with me and I could have possibly ended up going to prison for not paying my fine. That process repeated itself, Michelle and I meeting almost monthly up until about May, when Michelle got hold of me for the final time and said she'd managed to sort it out. So that was about 5 months after I actually received my court sentence that we finally got to a stage where we knew who we had to pay the fine to and how the fine was going to be paid. I just want to add a bit to that, because to be quite honest, I don't think there's any way on this earth that I would have had the capacity, the patience, the intelligence, the know-how, all the resources to do what Michelle did. And the only reason I'm actually paying my fine now is because of the level of help that Michelle offered me throughout that 5-month period. Fast forward, my fine has been paid in its entirety, which is obviously a really positive thing. Again, I would like to say paying the fine is a process of making a phone call. There's a lengthy automated introduction with a variety of options before you actually get to speak to someone. I had to do this, make this phone call each month throughout the several months that it took to clear the fine, certainly on the same day or on a day prior to the given day of each month. I think personally, it would have been easier if they could have set up a direct debit for me, but that option was not available. I remember asking. It was quite stressful. It was quite a stressful period, if I'm honest. Stressful because, well, it was my main problem that I had after I received my sentence. The main problem I had was paying my fine, and I'm not sure if I would have managed to pay that fine in its entirety if not for the help of Michelle and comedian Lars.
So as you can see, James was actually one of the lucky ones. Most people who get fines don't get fines alongside a community sentence where a probation officer is potentially on hand to help. Most people who get fines don't live near a court that's got a community advice service. There's only a handful in the country. So to hear more about court fines and people's experience of the court fine process, I'm delighted to hand over to my colleagues, Lucy Slade and Stephen Whitehead, who are the authors of this report, to go over their main findings. So over to you, Lucy and Stephen.
Thanks, Phil. So my name's Stephen Whitehead. I'm the head of data and evidence here at the centre, which means I oversee our research work. I'm shortly going to be handing over to Lucy Slade, our policy officer, who's been the driving force behind this research. Next slide. So first of all, I'm going to take you through a little bit about the background to the project and what we could find out about fines from the existing evidence base before we started our research work. And then I'm going to talk a little bit about the methodology that we used to try and fill the gaps in that evidence base. And you'll see as we go along, those gaps become quite apparent. And then I'll hand over to Lucy, who'll talk more about the people that we spoke to and about some of the conclusions we came to about what needs to happen to start fixing some of the issues that we identified. Next slide. So this project really starts with what Phil's already mentioned, which is the community advice service at Highbury Magistrates Court. And it was through Michelle and Jenny, who do brilliant work at that service, that we started to get a sense that the fine system wasn't really working. It was sometimes chaotic, it was sometimes unpredictable, it was sometimes dysfunctional. And they saw a lot of people coming through who are really vulnerable, who might have mental health issues, addiction, poor housing, or even just were facing real poverty, who are coming away with fines that they didn't know how to pay and they didn't have the money to pay. And that really aroused our curiosity. But our curiosity went further when we started to look at the literature and the evidence that was available and realized there was actually very little work done around fines, despite the really widespread use of fines and their potential to do real harm to vulnerable people. So we had to go back 20 years to find any kind of large scale or even semi-systematic look at how the fine system was working. And back then, as now, the system was confusing. It was not always responding to people's circumstances. People didn't really understand why they got fines, why the fines were what they were, or how they were to go about paying them. More recently, there has been work focusing on some specific offences, often gendered offences, which are linked to poverty, like TV licence non-payment or sex work prosecutions, which we know exacerbate existing financial hardship and can drive people further into offending. We also know from broader literature around government debt that fines are a one class of government debt, and government debt can be particularly problematic for people who are financially vulnerable because it comes with more stringent rules about repayment, more heavier penalties for non-payment, and greater enforcement power from people who hold that debt. And this is a problem for people in the criminal justice system. I'm not going to surprise anyone when I say we've got a really strong evidence base that there is a real link between poverty and going through the criminal justice system. So that made us really look at the fines, really want to look at the fine system. So next slide, please. And I think the first thing to be aware of is, although they're not very studied, fines are the day in, day out bread and butter of the criminal courts. Last year, 4 out of 5 sentences passed by the courts were a fine. And that's actually going up. That was only 2/3, 66% in 2012. So we're seeing an increasing use of fines. Next slide, please. And we can also see that fines are given out for a really wide range of low-level offences. This is the all of the offences, all of the most common offences for fines. You can see that speeding's right up there, but below that you can see television licence evasion that we've already said is linked to poverty. Vehicle insurance and not paying your insurance is another area which our work that Lisa will come back to later certainly suggests there's a potential for that to be a response to poverty as well. And then if we, next slide please, cut out those motoring offences, we can also see rail fare evasion, which is another offence with the potential to be linked to poverty. And we can also see prosecutions for truancy, which we know are probably linked to people in difficult family circumstances. And we also know that, of these offences, both truancy prosecutions and television licence evasion are some of the rare offences where the majority, around 70% of the people prosecuted for them, are women. So we can see that there's a potential for a particular impact on vulnerable women. Next slide. Then lower down this road, we can see some offences which really clearly have the potential to link to poverty, and actually fines being imposed here. So we can see not large numbers, but we do see fines still being imposed for prostitution offences and fines for begging offences. And I think there's such a clear link between these offences and people's lack of alternative financial solutions that it seems, just on the face of it, to make fines for these kind of offences to be very counterintuitive. I don't know quite how people who are begging or in sex work to pay the bills are expected to pay their fines, but I think we can draw some kind of obvious conclusions. Next slide, please. So I think it's also worth mentioning that we're using fines here as a bit of a catch-all term. We've looked at fine offences, but even people who don't get fined will almost always come out of court with something to pay if they've been successfully prosecuted. And this graph shows the total amount of different costs that were imposed on people in the 22-23 financial year. We can see that court fines are the greatest, but we can also see prosecution costs. The CPS will always apply for costs if it seeks prosecution. And if a person has pled not guilty, even to a very simple offence, these can run to hundreds of pounds. Courts are expected to make sure these are affordable, but unlike fines, which are meant to be directly linked to people's weekly income, there's no very clear guidance on what that affordability might look like. We can also see the surcharge, sometimes called the victim surcharge, and this is imposed on almost everybody who has a fine, with very little discretion for courts around affordability at all. Sorry, almost everybody who has any kind of prosecution. The level of the surcharge will be dependent on the offence you get. If you get a fine, it will be 40%, but if you get a more serious sentence, like a community order or custody, it will actually be higher. And then we can also see compensation orders, which are there for offenders to pay back, pay restitution for harms that they've inflicted. And these are actually not linked directly to people's capacity to pay, they're linked to the scale of the harm done. Again, they're meant to be affordable, but there's not necessarily very clear guidance on what that means. So we can see that although these other costs are lower in total in terms of what's being imposed, the fact that they're imposed more widely with less clear options for making sure they're affordable, mean they have particular potential to do unintended harm to people on low incomes. Next slide, please. So this slide is actually an interesting one. Guidance suggests that fines should be paid back within a year, or it should be possible to pay back within a year. Most people on low incomes will pay fines from instalments through their benefits or through, as we heard earlier, having to make a phone call every month to make a card payment. And we can see that in 2019, the last year for which data is available, only half of fines were repaid within the time period. And this may suggest that people aren't paying, but it may also suggest that the scale of the fines is such that people simply can't pay them off in that time. We can see even after 18 months, still only 57% of the fines imposed were paid. So we see that for a substantial minority of people, it's taken them a really long time to pay back that fine, and that may be reflective of their inability to pay. Next slide, please. So that covers off some of the publicly available data, but I think it's really worth pointing out what we don't know from the publicly available data. I think it's worth knowing that although courts are meant to gather information on people's financial circumstances when they're adjudicating the levels of fines, there's no central collection of that data, which is a real missed opportunity to actually gather data about the economic circumstances of people who are being fined. So we don't really have any data on their economic circumstances. Also, as identified within the Lamy review, there's actually very poor collection of ethnicity data in the magistrates court. No ethnicity data is correct around summary prosecutions, which are 96% of fines, and then even in other cases, data collection is poor. So we really can't say very much about the ethnic balance of people who are receiving fines as opposed to other sentences. And lastly, while we do have some data on repayment rate for fines, there's no capacity to link that back to people's characteristics. So, as I mentioned earlier, I think these non-payments or slow payments, they might be linked to people's inability to pay, but it's just not really possible to investigate what it is that stops people paying fines, which is another kind of, as a researcher, really frustrating problem. Next slide, please.
Oh yeah, we're just changing the presentation, so could you just give us 2 seconds?
So I'll just keep talking because that's what I like to do. So next, I'm going to talk a little bit more about the things that we tried to do to actually fill in some of these gaps in the evidence. And one of the things that we did was we worked with Citizens Advice, who are one of the kind of major social welfare advice providers in the UK, have a really huge number of clients. And I worked with Citizens Advice, and I should really recognise the work of Tom Hunter over there, who really helped us with this, to look at within the Citizens Advice client database. So that's a database of people who are seeking social welfare advice, who are probably quite vulnerable. Which kinds of people are more likely to have magistrates' courts arrears, so are struggling to pay back their fines? And we found that over a real range of dimensions, magistrates' courts arrears are associated with indicators of financial vulnerability. We saw that people in social housing are more than twice as likely to have magistrates' courts arrears as owner-occupiers. Unemployed people nearly twice as likely to have them as people in full-time employment. Single parents, who are overwhelmingly going to be women, are 1.3 times as likely to have magistrates' courts arrears as people in couples with children, and people in receipt and benefits 1.2 times as likely as those not in receipts of benefits. Obviously, this is within a subset of the population. This is not across everyone in the UK, and we can't necessarily easily extrapolate it. But in the absence of other evidence, this is at least suggestive that people who are in magistrates' courts arrears, who are struggling to pay back their fines or are behind in fine payments, are so because of financial vulnerability. Next slide, please. So that was a really interesting set of findings, but we really wanted to find out more about what people's experience of the system was like and how it was impacting them. So we, as mentioned, did 56 interviews with people who've received fines and were on low incomes in 10 locations in England and Wales. And we wanted to find out about their views of the process, about their views of the fairness of the sentence and the fairness of their fine amounts, the impact of the fines, and then for those who had experience of it, about their experience of facing enforcement action. And we were speaking to people over 18, residing in a low-income household, so that's C2, D, or E, who'd received employment line in the last 5 years and who'd been negatively impacted by it. So next slide, please. In a second, I want to hand over to Lucy, who's going to take you through these findings in a bit more detail. But I did want to kind of give a picture of the kind of people we're speaking to with one case study. It's a gentleman called John, who I kind of remember speaking to really clearly early on in the project. He was an older gentleman with a pulmonary heart and lung condition that stopped him from working. He was dependent on benefits, and he'd been stopped for speeding, and then after speeding had been picked up as well for having his mobile phone close to hand and not wearing a seatbelt. He went to court. He actually pled against the advice of the GC solicitor not guilty to the phone offence, so they pled guilty to the other two. And at the end of it, he came out with a £1,600 fine, which he was going to pay £5 a week. And that was, despite it being a relatively low amount, that was causing him real anxiety, real hardship. He talked about struggling to make ends meet. He talked about really cutting back to the bare essentials in terms of his lifestyle. And he talked about the anxiety of the consequences if he'd make a payment. I think there's three things that really strike me about this case study that were actually quite common. First of which is the kind of serious, significant impact of what feels like a relatively low amount. And this is particularly exacerbated by his case, paying back £1,600 over £500 a month. That's just over 6 years. That's a really long time to be on a reduced income when that's having a negative impact on you. Secondly, what was really striking was that he didn't feel that his circumstances had been taken into account. He says he told the duty solicitor that he was on benefits, but he wasn't even sure if that was mentioned in court, and certainly there was no detailed discussion of his financial circumstances. And thirdly, it's very difficult to see how a fine this high was appropriate for this person, just looking at the legislation. Without wanting to get too much into the weeds of it, a person like John, these offences should be around double his weekly income, and for a person on benefits, their weekly income is assumed to be £120. He's obviously ended up with really significantly in excess of that, which is striking even once prosecution costs for a trial are taken into account. And it seems really likely that the court hasn't taken into his account the fact that he's on benefits, and instead treated him as though he hasn't provided any financial information at all, really ramping up the amount that he has to pay beyond what seems potentially to be intended in the legislation and guidance. Obviously, we weren't there. We're relying on self-reports, but it does seem like something has gone wrong in this case, and that's a kind of a pattern that we saw over and over again. So now I'm going to hand over to Lucy to say a bit more about that.
Thanks, Stephen. So one of the most prominent findings from the lived experience interviews is how fine payment worsened people's financial vulnerability. For many people, it made stretching budgets to cover daily essentials really challenging, and these essentials, as we all know, are getting harder to pay as a result of the highest inflation we've seen in 30 years. And for those already living in poverty, paying their fine meant they just did not have enough money to buy the basic things they needed to live. We were told about how some people went into arrears on their rent, on their bills, they were skipping meals and using food bank as a result of having to pay their fine. And we've frequently heard that people got further into debt, either from borrowing from friends or family, taking out credit cards, or taking out loans. And these findings and the stories that we were hearing, they're a world apart from the aims set out in the sentencing guidelines, which states that fines shouldn't be forcing offenders below a reasonable subsistence level. And I think that's really demonstrated by this quote from one of our interviewees who told us, "Financially, I'm living day to day as it is, hand to mouth. So to find an extra £20, it may not seem a lot, but it's a hell of a lot for me." And this financial strain, quite understandably, was having a significant impact on people's mental health, causing sleepless nights, stress, all of as a result of worrying about not being able to afford their next fine payment. And some people describe the mental toll and anguish of constantly thinking about how to stretch and manage their budget around paying their fine. When we see that in this quote here, the impact of the fine, it was stress and anxiety, really. If I didn't have the money to replace it, what else was I going to cut back on? Because if I was going to cut back on food, I'm going to be hungry. If I'm going to cut back on my rent, I'm going to be in debt. And we heard this particularly affected those who were paying off small amounts for long periods of time. So it might be as low as £5 per week, but they were feeling that this had such a negligible impact on reducing the total amount that they owed. Total payment just felt endless and impossible to achieve. As one person told us, when you see the start date and the end date and you just see a year or 2, 3, 4 years, it's just like, oh my God, it's going to seem like it's going on. It just seems like it's going on forever. So from these interviews, we also identified a number of points in the court fine process, which we believe are leading people on low incomes to receive a fine that is beyond their means to pay. And firstly, we heard about significant variation in how the courts collect and use people's financial information. Some people told us that they were filling in standard means assessment form while they were in the courtroom. But in some cases, this was really limited to just their income, what they earned, and whether they were on benefits, which they didn't feel like captured the complexity of their financial situation and was leaving out really important information, such as if they had any debt or if they had any children and dependents to care for. And some people were telling us they were just asked on the spot in the courtroom what they could afford to pay, which they found really hard to do accurately and under pressure. And some people said they were receiving a fine without any discussion about their finances at all. And we heard from several people about problems with the financial charges that Stephen was talking about earlier, such as these are the prosecution costs, the compensation orders, the surcharges, which are added on top of the fine. And we were hearing that the amounts of these charges significantly exceeded the fine itself and was pushing the total up to an amount that they just couldn't pay. And in some cases, they reflected on the original fine being quite affordable and proportionate, but these financial charges were doubling or tripling the amount that they owed to the court. And that's how the person in the second quote here felt. He said that the original fine of £60 felt quite payable, but it was these additional charges made the total feel, in their words, extreme and beyond their ability to pay. And as Stephen has spoken about, these charges aren't means tested in the same way that the fine is supposed to be. We also heard about payment plans that were arranged with the court exceeding people's ability to pay, so the amount that they were being asked to pay of their fine total each month. Some people felt that the amounts just weren't taking into account the reality of their very limited disposable income. And as a result, these monthly payments were taking a large proportion of their budget, which they needed to pay for basic living costs, to the food and their rent. And some people felt there was a lack of flexibility from the court over reducing these payment plans that had become difficult to afford. And we've spoken about this, but while some people have been able to agree with the court, they would make these small monthly instalments. So maybe the £5 per week was affordable, but it meant that they'd be losing this income and paying off their fine for years. And this was particularly a problem for those who are paying multiple fines at once, which had snowballed to quite a large amount. And this is demonstrated by the second quote here. They'll fine you loads, even though you owe them loads. They don't look at that. They don't think, oh, this guy might need some help, but he's constantly getting fined. But they never do. It's just a revolving door, in, fine, out. And again, what we're hearing is a complete divergence in practice from what the sentencing aims should state that should be happening. It says that a fine should be set at an amount that is payable within 12 months. We also heard about the enforcement tactics of the court, particularly the threat of bailiffs to enforce unpaid amounts, negatively impacting people's mental health, making people feel harassed and anxious. And some people admitted to us that the fear of their possessions being taken made them avoid answering the phone or opening the door in case it was the bailiffs. And they told us they hadn't paid the fine because they just did not have the money. And the threat of bailiff action didn't change this reality. And in fact, they felt that the approach taken to enforcement by the court was actually making the fine harder to pay because the involvement of the bailiffs annulled any payment plans they had set up, so the amount was due immediately, and increased the total that they owed to the court. This is one person told us. Obviously, if you miss it, your fine can triple and double, and the next minute you've got bailiffs or you're back in court again for another fine, and it just escalates. And we heard from a couple of people that the court was harder to engage with than engaging with when they owed money to commercial creditors or even local authorities. It was felt they were more flexible and responsive to financial difficulties, that you could call up the local authority if you hadn't paid your council tax because you're struggling, and they would be able to be more amenable to adjusting plans, or you could pay off small amounts of your credit card to keep the wolf at the door, as one person told me. But courts felt much more rigid and less flexible when things got hard to pay. And of course, we've got to acknowledge that these findings are going to be no means universal to everyone who receives a court fine. But it was really striking to us when we were doing these interviews that even within the small sample, we saw a real spectrum of how people were financially impacted by the fine. And these two quotes here demonstrate the two ends of the spectrum. We had one person telling us that the fine itself was manageable, and another telling us that they faced the choice between paying their fine or buying food. And this suggests that the system is just not meeting the sentencing objective, which states that the financial impact of fines should be experienced equally. And this is having particularly serious consequences for some of the poorest in our society. So as well as the lived experience interviews, we held workshops with magistrates to understand their perspective of the system. And they told us they often feel that they have limited options than to sentence people to a fine who come before them in the court who are clearly on low income, they might have complex needs, or are even homeless, despite knowing they will not be able to pay it back. Yet their offence doesn't warrant a more serious outcome, such as a community order. And giving them a fine felt pointless, and they were also worried about the impact this would have, worsening that person's poverty, and whether it would drive them to commit more crime to afford to live. And this concern's summarised quite nicely by the first quote here. Are we going to be the straw that breaks the camel back, and this is going to push them over into more crime because they can't get to a food bank? So from these findings, we've identified 6 areas for development that we believe are needed to improve the court fine system. Courts need a more consistent framework for setting the levels of both fines and financial charges, which are more responsive to financial circumstances of individuals and places affordability at its centre. Courts also need a better system for assessing people's finances, which is more in line with the good practice that we know is going on in the debt advice sector. The court service needs a customer support function to help people overcome administrative barriers to making payments. And we think sentences need to be supported to adopt a problem-solving approach to fine non-payment and explore alternative arrangements with people who are struggling to pay. And our research found that there are some people who cannot afford to pay anything, which won't be a shock to those working in the debt advice sector. If you remember the quote from the previous slide from the person who said they were living hand to mouth, which made finding £20 a hell of a lot to pay. In these cases, sentences need to have an alternative option than giving a fine. And lastly, we think we need a more comprehensive court fine data system to fill in those important data gaps that Stephen ran us through. So that's been a summary of the findings from part 1 of this project, which really focused on evidencing the issues that are at play. Part 2 is going to start in July of this year, so very soon, and we're going to be working with policymakers, practitioners, and people with lived experience to identify how we can bring about this reform to the court fine system. That's all from us.
Thank you very much. Thank you, Lucy. Thank you, Stephen. Well, I found it fascinating. I hope you all did as well. It's with great pleasure that I will now ask Val Castell, Chair of the Adult Court Committee of the Magistrates Association, to give the view from the Magistrates Association about court fines and her response to the report. So over to you, Val.
Thank you, Phil. Thank you very much for inviting me to be part of this today. I think, not surprisingly, given that magistrates' views were part of the findings that this report was based on, the report does echo many of the concerns that magistrates have got about trying to take money off people who basically haven't got any. I wanted to just briefly focus on 2 of the key challenges that were set out. And one of them is the sentencers need to be supported to adopt a problem-solving approach to fine non-payment. And the first thing I wanted to say is that we used to run fines courts on a regular basis, and we would really welcome a return to those courts. If people are before us in court, there are things that we can do to help. We can look at the level of fine that's been imposed, and if maybe that was decided in absence and based on the standard amount where we haven't got any fines information, we may be able to remit some of that and bring it down to actually what the real situation is according to income. And just to pick up on the surcharge, it is to a degree, of course, it is dependent on income, because it's a percentage where you've got a fine. So that percentage would be reduced as well as the actual fine amount. But I also wanted to pick up on the point number 5, sentencers need a clear alternative to fines and financial charges for people who can't afford to pay any amount, including the reconsideration of unpaid work. And I'm sure many of you are aware that the law says that we can only impose a community order, which would be what we'd need to do to impose any unpaid work or rehabilitative support. We can only do that where the maximum penalty for an offence is custody. And for offences where the maximum penalty is a fine, we can only impose a fine or a discharge. And I note that most of the offences that were actually listed in your most commonly offences where a fine is most commonly used, most of those, almost all of them, have a maximum penalty of a fine. And I note that this point does actually talk about reconsideration of unpaid work, which would suggest that it's more appropriate to those situations where it is actually a maximum sentence, including custody. Whereas I think our perception would be that most of this problem is geared towards those offences for which only a fine is appropriate, rather than those where it could have been a higher level order, but a fine's been given instead. So where we've got a maximum penalty of a fine, say as things stand, we can only impose a fine or a discharge, and usually a discharge would be where there's either considerable mitigation or offending's out of character, or there's been a long gap, and this is clearly a blip. But the MA has been working on a couple of approaches to do with this. There's two bits of legislation which weren't actually brought into effect but are there on the statute books. Section 151 of the Criminal Justice Act 2003 allows for a community order to be made for an offence which is not serious enough to warrant a community sentence for a persistent offender who has on 3 previous occasions received a sentence of a fine, if the court considers it would be in the interests of justice to do so. The problem with that is that if you've got something which normally would only be sentenced at fine level, if you are imposing a community order, that is moving up the tariff, and there's concerns about the implications for breach, what would happen if that wasn't adhered to, and so on. But the other one, which we have higher hopes for, frankly, Schedule 6 of the 2003 Courts Act contains provisions about the discharge of fines by means of unpaid work, stating that the court can, on the application of a fines officer or of its own motion, make such an order when the offender's financial circumstances make the enforcement of the fine impractical or inappropriate. And we'd actually like to see that extended not just to unpaid work, but maybe to allow small amounts of rehabilitation activity requirement sessions or education and training sessions. And it would really mirror very much what can be done on conditional cautions and so on then for lower level offences. So instead of keeping on putting these, more and more financial burden on people, we can say, well, it is still a fines outcome. We're not moving up the sentencing tariff, but as a means of discharging it, if you haven't got the money, you could pay it off by doing a certain amount of unpaid work or doing a certain amount of rehabilitation activity. Compensation couldn't be included in that to be paid off, but I think we would hope that repayment of surcharge could also be included in that. So I just really wanted to bring that to your attention, and we see that as being quite a hopeful way of helping with some of these problems.
Thank you very much, Val. Lots of really interesting views, and I'm sure in the Q&A section people will have questions, and as we've discussed before in our sort of pre-meetings, if there are any policy questions, I'll try to make sure they don't come your way. So yeah, really fascinating, and I'm sure I'll pick up on a number of those points in the Q&A session. I'd now like to ask Damon, Chief Executive for the Centre for Responsible Credit and a very valued member of our advisory board, to give his views. So over to you, Damon.
Well, thanks very much, Phil, and I'm delighted to be here at the launch of the report. I do recommend that everybody on the call reads the report in full, because I think it makes a very compelling case for reform. I also must say I found reading the report very depressing. If I were to cast my mind back 30 years, I was then a young debt and benefits worker in Citizens Advice in Warwickshire, on a project that was funded by Warwickshire Probation Service. And my job was to take referrals from probation officers, many of whom were dealing with people who had also been fined, and to help them claim benefits and deal with their debt issues in a holistic way. Much of that work meant that I was also required to provide information to the magistrates' courts at means inquiry hearings for people who had been called back to court because they'd not paid their fine. And one of the things that was actually quite helpful about that project was the fact that money payment supervision orders would sometimes be made, basically to allow us more time to work with the individuals to actually make sure that they were getting the benefits that they were entitled to, many of whom were missing out on benefit entitlements, and to work with them to provide a more holistic solution to their debts, because clearly many people had not just magistrates' court fines, but also rent arrears or council tax arrears and other debts. And so taking a holistic view of the financial situation actually provided an opportunity for the criminal justice system to assist people to get what they were entitled to, and also to get access to the support they needed to deal with their financial problems. Now, I say it's depressing because, I mean, obviously 30 years down the line, I can still see that many of the offences that Stephen and Lucy have set out are clearly related to poverty. You know, whether that is TV license non-payment or not driving with an MOT, no insurance. We also found that 30 years ago, there was quite a lot of people being put onto community orders for things like tampering with electricity meters, attempting to bypass the meter because of fuel poverty issues and things like that as well. So that's not changed. But what's more depressing, I think, is the fact that it's harder now to actually resolve some people's financial difficulties through benefit take-up. So we run a project, or we're leading the delivery of a project in parts of Southwark and Lambeth at the moment, which receives referrals from GP practices and aims to maximise incomes, whether that's getting people benefit entitlement, getting social tariffs for water, or helping with energy costs and those sorts of things. And whilst that's successful, in about half of the cases that are coming through that project, in terms of increasing people's incomes, we're increasingly finding that for many people, there is no opportunity to increase incomes in any significant way. They're getting what they're entitled to. And so the only support that can be provided to many people is very short-term assistance for things like food banks. And I think we've seen just this week, you know, a horrific increase over the last 5 years in food bank use being reported by the Trussell Trust, or things like vouchers to help with fuel payments and things like that. But people are generally, or many people are getting what they're entitled to and are still unable to make ends meet. And that's been the story of certainly the last, well, increasingly so for the last 10 years, and then particularly impacted through the pandemic and in the years after with the cost of living crisis. So we're in a desperate state, or many households are in a desperate state in terms of trying to make ends meet at the moment. And we also find, you know, through the project that I've just mentioned, that people have also, again, got rent, council tax arrears debts and other debts as well. And there just isn't the money there, even after incomes have been maximised, to make offers of repayment to creditors. So this so-called negative budget effect that's been well reported by Citizens Advice is now a huge problem. People simply can't make ends meet on the money that they've got and the money that they're entitled to. So it's in that context that, you know, inevitably, when it comes to court fines, that people will be unable to pay the fines, or, as the report clearly lays out, they will pay the fine, but it will have an effect somewhere else. So there is this waterbedding problem that we've got. You press down on one part of the waterbed, it just pops up in another area. And so, you know, fines which carry very serious enforcement consequences, if those are paid, it will be at the expense of increased rent arrears, increased council tax arrears, increased indebtedness, people borrowing to pay off the fine, and all those sorts of things. It just simply pops up elsewhere. And we know that that has a dramatic impact for mental health, for stress, anxiety, for physical health as well. There's a clear relationship between poverty, debt, and health, which cuts both ways. And so that increases costs elsewhere in the system. And I think we do need to take a systemic look at what is actually happening here, because it's pretty pointless, although we can all recognise the need for justice and that people need to be punished for offences. We also have to recognise that it is simply increasing the costs within the system elsewhere for other stakeholders, including the taxpayer, that ends up footing the bill for all of the increased health issues that arise from these sorts of things, or indeed the fact that it, you know, then impacts people's ability to get back into employment and has knock-on impacts there as well. So what may be a system which provides some element of individual justice, individualized justice, can actually be a system which is actually not effective once you take that more holistic view of it. And I think that's something that we need to perhaps consider moving forward. I think, firstly, I would just say I'm not here to provide any solution, but as Phil pointed out, you know, this is the first stage of the project. I think it does build a compelling case for reform, but I think we do need to look at some of the wider systemic issues. I mean, personally, I have no problem with the decriminalisation of TV licence non-payment, for example, and I know the government has shelved that as a possibility. It would require a huge look at how the BBC was funded as much as anything else, but I think it's, you know, when we look at things like water, where several years ago, probably over a decade ago now, at least maybe 20 years actually thinking about it, they used to have the power for disconnection. That was removed from them. So people can't get disconnected for falling behind with the water arrears. They've now been encouraged by Ofgem to do more to identify and help people who are actually struggling to pay their bills as a result of that move, whereas previously they would just have relied on the fact that they could disconnect people. They didn't need to investigate their means, therefore they weren't particularly sensitive to actually assisting people in problems. We have similar issues with energy prepayment meters, where it's just too convenient for the companies to frankly put in a prepayment meter, and therefore, you know, they're not providing the level of assistance for people who are really struggling with their energy bills at the moment as well. And I think we've got to look in the round, therefore, at actually what the enforcement powers of some of these debts are, particularly as well in relation to government debt, you know, so the ability of government to just deduct out of benefits and leave people on levels of income which are clearly below subsistence level, I think needs to be looked at as well. So that whole waterbedding effect, where fines sit within that, I think is pretty critical, but also to look at that possibility of actually when somebody is being fined, is it an opportunity to actually provide support for people to make sure that they're getting what they're entitled to, and to get them that holistic support that they need with their debt problems. So I'll leave it there, I think, Phil.
Thank you very much, Damon. So now's a chance just for us to have a bit of a Q&A back and forth, and obviously for those people online, please put your questions in the Q&A chat. But just actually picking up, Damon, on something you were saying, I'd be interested to get your view on decriminalisation of TV licence evasion. So if you've seen from the report, a lot of fines are given out for TV licence evasion. I have been around the justice system for about 20 years, and I don't think I'd fully understood until this report that TV licence evasion is a criminal offence where council tax isn't. I know you've recently done a report on council tax and cost of living crisis, which also makes for slightly depressing reading. So what for you is the advantage of a decriminalising TV licence evasion, given that council tax evasion and cost of living crisis remains a pertinent issue? So I'd just be interested to hear your view on that.
Well, sorry, excuse me. As I say, with water and things of this sort of nature, once you provide an unlevel playing field for the enforcement of different debts, then you're effectively saying that somebody should pay their TV license, or in this case, whatever it is, fine, at the expense of something which has a less problematic enforcement process. So you're effectively just shifting the burden from TV license, in this case the BBC revenue, to other elements of the budget, which will then have to take the strain for that. The question with TV license is therefore whether it should have such a privileged position in the scheme of enforcement, or whether there are other ways of paying for the TV license which don't require such a punitive enforcement regime, and which would, deliver the same thing and therefore take a lot of people out of the criminal justice system, which obviously costs a lot of money to bring people before the courts for TV license non-payment, and doesn't, to my mind, really result in much increase in revenue. People who are going to pay the TV license going to pay the TV license. People who are struggling to pay the TV license will continue to struggle to pay the TV license. So I think that needs looking at in the round. It just doesn't make sense to me to actually bring people into the criminal justice system for the payment of a state broadcaster.
Useful. Thank you very much, Damon. Val, so a question in the chat, which I thought would be useful. So sort of a very basic one. So how do you, as a magistrate, assess someone's ability to pay a fine when passing sentence? And I guess just kind of following up again, just for me reading the report, I naively assumed means forms was everyone had a means form, and clearly from some of our interviews that wasn't the recollection of people who were fined. So just interested in your observations on how that process works.
Okay, well, let's start with means forms. It used to be a standard process, yes, that everybody that came into court filled in a means form. It was one of the effects of COVID that we stopped passing bits of paper between people as much as we could, and that's where the disconnect came in. So in some places means forms have been resumed, and in some places they haven't, and we're just continuing to ask people in court, what amounts do you regularly take home? What's the average over the last 6 months if it's somebody that's self-employed, and get an idea from that, just what the fine level needs to be. When it comes to ability to pay, some of this is set out in your report, but just to explain a little bit more, the amount of fine is based on the income that we assess, and then, as I said in the report, it should be an amount that can be repayable within 12 months. The exception to that is where there's compensation, and then it can spread as far as 3 years. Now, I mean, generally speaking, if you've got somebody that's on benefits and you're talking about a payment rate of £5 a week, which is what we are told is the minimum that we can order, then you're talking about about £250 a year would be the maximum amount that you could actually order. And sometimes when there's been compensation where people have either stolen things from, and it's not so much the shops who can afford a certain amount of loss and tend to factor that in their businesses, but where things have been stolen from individuals, maybe the insurance doesn't cover it, where there's been injury to individuals, it is reasonable to look at compensation for that, and then sometimes it will go over the 12 months. Where I think that tends to fall down is where you've got multiple offences coming in, because what you're not looking at is what is already on the court record. You're looking at this offence and the ability to pay that amount off in 12 months. And then if you're consolidating that with other amounts that are owed, then that can stretch into the future for some considerable distance.
Yeah, that's useful. And another question for you, which I'm going to slightly change because I think there's part of it that you won't be able to answer, which is for those people, just so people sort of understand the reasoning behind it. So it is possible at the moment to get as we heard from James's story, to get a community sentence. I think he was suggesting he had a suspended sentence order and a fine. Equally, some people, it's not many, can get a custodial sentence and a fine. Just, I'm not asking you to justify that because that's obviously sentencing policy, but just sort of explain the reasoning, I guess.
Okay, I mean, I think there is certainly some confusion there, and if it was for the same set of offences on the same day, then no, I very much doubt that he was given a suspended sentence order and a community order and a fine. I suspect what probably happened was that he was given a suspended sentence order, and as requirements of that suspended sentence, he was required to carry out, whatever unpaid work or do some rehabilitative work or whatever, so that it would be the same sort of requirements that you would get on a community order. So I think that's probably where that confusion's come in. At present, what the law says is that when we make a community order, one of the requirements of that order should be there for the purpose of punishment. And where you are making an order which is just for rehabilitation, so it might be a treatment requirement, or it might be a rehabilitation activity requirement or something like that, and the person can't, for whatever reason, carry out unpaid work or can't have a curfew, then you might add a fine as an element of that, sort of a small fine on top as the punitive element, or instead of the punitive element of that order. Again, I think maybe there was a financial requirement as part of the suspended sentence order. I would think it would be very unusual to actually be given those three separate punishments. So
I think that's right. But yes, I mean, it is people often have, and also can often have multiple sentences running alongside each other. So we don't know the exact circumstances of that case. Stephen, did you want to come in there?
Yeah, I was just going to say, I mean, when we spoke to magistrates, this issue of the punitive requirement was something that attracted quite a lot of disquiet in terms of forcing magistrates to impose fines in cases where they felt there was limited or no capacity to pay that fine, and that was something that really stood out.
Yeah.
There is. Sorry.
Sorry,
I think the new imposition guideline that's just being consulted on is due out soon. It clarifies a little bit more what we need to think about in terms of punitive requirements. But I mean, certainly as far as using a fine as, instead of a punitive requirement on a community order, the same applies as imposing a fine as a separate sentence, that it has to take into account whether it's going to cause undue hardship, if that financial penalty is put on somebody. So you do have that same caveat on that.
That's useful. Damon, just a question for you. So where would you advise someone who's struggling to pay their fine to go for support? So we heard from James's stories. Luckily, he could take advantage of a service that we happen to run up in Highbury. But for people who maybe don't have access to that, what would be your advice?
First port of call is probably going to be Citizens Advice or National Deadline. I know we'll have a lot of online materials around this, which are really good in terms of setting out the procedures and what's likely to happen, and the enforcement process and so forth. But I think the fundamental problem that we have there is that those services are overstretched. As I mentioned, 30 years ago, we were in the fortunate position of having a specific project that was embedded within Warwickshire Probation Service that provided this support, which was very well appreciated by magistrates as much as anybody else, because it meant that they would have, very comprehensive information about the offender's means put before them. It would sped things up enormously in terms of their decision making about the level of fines, and also when it came to people who had not paid their fine, we were able, because of our relationships with the courts, to intervene and make sure that people did not go to prison for not paying their fines. We were able to intervene at the means inquiry hearing stage as well. So those sorts of services, I think, are what we need. We don't have them. And in the meantime, obviously, local authority budgets, which are the main funder of local citizens advice bureaus, are under enormous pressure, with many local authorities declaring effective bankruptcy and looking at how they have to reduce their spending to just statutory minimum requirements. So we've got a huge problem, but fundamentally, we need advice services at the local level working with magistrates and the courts, and we need it to be resourced. It's going to take money to do it.
Excellent. Yes, well, there seems to be buckets of that around at the moment, so that shouldn't be a problem. Yeah, I mean, in the sort of 12 months after, or sort of following this report, well, as I said, and as Lucy said, we'll be looking at policy and practice options to assist the situation, and clearly some of those will have a financial tag. And as an organisation that has been a keen supporter of community advice and indeed runs one bureau up in Highbury, we're always struck by the people who we take to visit it, that most of them say, why does this not exist everywhere? To which we would say amen. But the obvious answer is well, it's two really. It's space and cost. It's a comment rather than a question from Penelope, which is about the single justice procedure. So just to kind of give background for that who don't know about it. So it enables a single magistrate supported by a legal advisor to decide on adult summary only non-imprisonable offences, and it operates remotely. It applies when defendants either have pled guilty or, which I think is the majority of them, have not responded to a notification that they're being prosecuted. So in that process, you can't impose a community order or a custodial sentence. It's essentially discharges or fines, or I think possibly compensation orders. I can't remember. I'm sure Val can tell me. I can see her looking quizzically. I'm not sure. And I think one of the interesting things or difficult things about the single justice procedure is, unless an individual provides information on their means, the court proceeds on the basis of an assumed weekly income of, I think it's £400. 440, sorry, I'm told reliably it's 440. Now we did, in our data review, we did a little bit of research around the use of the single justice procedure and fines. So we found about 700,000 criminal cases had gone through the single justice procedure. We actually found for those in which got fines, the average fine was lower than those that had been in court. But again, that probably suggests, because they're low severity, the ones going through the single justice procedure. I know the Magistrates Association, I don't know if Val wants to come in at this point, has said things about how it wants the single justice procedure to operate better. But I might also just leave that as a comment if Val is happy to leave that as a comment.
Well, I don't mind sort of briefly talking about this. I mean, there are concerns with the single justice procedure, but actually a lot of them are the same concerns that we have about, the people that come into court as well. It's how you actually make the forms and the requests for information sufficiently understandable so that the information we get is good. And the same issues pertain to, say, whether we've got somebody in court or whether we're doing something via single justice. But I think also that the other half of that story is that I think a lot of the time fixed penalties, which of course are not actually income dependent but are generally set at a fairly low level, it's where those systems have fallen down again, sometimes because the procedures are quite complicated or the forms are not that easy to understand, that we end up with things coming through single justice. So a lot of the speeding and all that sort of stuff, somebody's caught speeding on camera, a lot of it would be dealt with, I think, probably through the fixed penalty system if everything wasn't quite so difficult to understand. it was better publicised, you know, things like the requirement to make sure DVLA are told via the V5 form when the vehicle, the registered keeper has changed address, because it's things like that that cause a lot of the problems, and a huge number of the people we see coming through these systems are because of things like that.
Okay. Stephen, did you want to come in?
I was going to say, we didn't in our interview speak to anyone who'd been fined through the single justice procedure. We did speak to a number of people who'd been fined while not in attendance, often because they simply hadn't received, or potentially hadn't understood or recognised the summons that was telling them of the time that they needed to attend in court. I think some of those people then succeeded in having their fines amended to reflect their actual material circumstances, and some of them didn't. We also spoke to a few people who weren't aware that they'd been fined because they hadn't received the letter until the bailiffs contacted them, and that some of these people reflected with some degree of justification that if the bailiffs could find them to chase them for the debt, why couldn't the court find them to issue a summons to the correct address?
Yeah, and I think the answer to that is, again, you know, it's the complication of things like making sure that the DVLA notifications are right and done at the right time, and so on and so forth, because the court will rely on what the prosecutor has told them about, you know, the individual and where they are. And if DVLA, again, you know, why you could say, why can't DVLA tie up changes to driving license details with change to registered keepers details? But that's kind of not my field of expertise. But I think, you know, there's a lot of these complications in the background that I think cause some of these problems. And of course, you know, the court, it isn't there as a people finder. You know, it is there to put things in place for whoever it is that's prosecuting the offence.
In fact, a question I actually meant to ask you at the start. According to the figures presented in the report, which was, I think, for people fined in 2019, so we've had the ability to look at what's happened to them over the past few years. It would seem that 43% of them had not paid their fines by 18 months having elapsed since the sentence be given. And that, from what I remember from looking at the data, has held relatively consistently as a figure. This isn't a new phenomenon. Now, some of what we couldn't say in the report is how many of those people couldn't pay and how many of them simply won't pay. But I guess just as sort of psychologically as a magistrate, what does that leave you feeling like if 43% of people 6 months after they should have paid still haven't paid? I'm just kind of interested in what that feels like.
You know, it's a perennial thing with the Magistrates Association. It pops up fairly regularly. You know, so why do we keep finding people when nobody's actually paying the blooming fines? And again, you know, I think answers are probably many and varied. But I think it's partly the, as I say, the stacking up people's fines, so that actually if somebody's, you know, got a number of consolidated fines and they're paying them off, then actually this individual fine that you're looking at the data for, it won't have been paid off in time because other ones are being paid off first. So that's, I think, probably a large part of the answer. I think there's also, as Stephen said, you know, people who aren't even aware they've been fined, and by the time the process catches up with them and they realise there's a fine against them, then you're already, you know, a lot further downstream. So I think those come into it as well. But I think the MA has expressed some concerns about the levels of surcharge, and you'll probably be aware we were also very concerned when the court's charge came in. There's sort of adding extra financial burdens to people, and it's, you know, something that we have said is that we have no data on this, but we would suspect that with the surcharges increasing, probably the level of fines are decreasing, the number of times costs are rewarded are decreasing. We sort of suspect that there's probably not an extra amount of money being sort of included in the system, but that more of it is surcharge as opposed to other things. And the way that fines are collected, where there are a number of things, it's usually, you know, compensation gets taken first and fines get taken second. And yeah, I can't, I mean, I don't quote me on this, I can't remember the exact order apart from the fact that it's compensation first. But I think that will also make a difference when it comes to the sort of financial things that have been ordered as to how long it may take for a fine to be paid, because that's not going to be the top of the heap when it comes to how things are actually taken out of the income that's being received back in. Does that make sense?
That does make sense. Dana, you had your
Yes,
hand.
I was really struck by one of the tables in the report, actually, which was about the amount of time and the amount of the fines that had been paid off at 6 months and 12 months and 18 months. And there didn't seem an awful lot of benefit beyond 6 months. So I think you get to 45% of the fines being paid off within 6 months. But by the time another 6 months have gone past, you've only got a further 7%, and then 9 or 10% by the time the 18 months sort of comes up. So there doesn't seem like the post 6 month collection process is yielding an awful lot in terms of what I presume is quite a lot of effort going into that. So on a cost benefit analysis, you'd say, well, actually, it looks like anything after 6 months is costing us a fortune to try to get in, and then we're actually not recovering very much of it at all. And maybe that is to do with the fact that I suspect a lot of people will be low paid in the private rented sector, single men, often for quite a lot of the offences as well, relatively young age profile. So, at 6 months, a tenancy comes to an end ordinarily, and people are moving. And then we've just been talking about the problem of people not knowing that they've subsequently, had a warrant issued, or, these sorts of things, and bailiffs paying to trace them and all of that sort of things. So I'm just kind of wondering if there is a fundamental issue that maybe the period of time is just too long, and actually, if we could get fines collected within 6 months and set them at a rate which was affordable to be paid back within 6 months, then maybe that would yield better results.
Yeah, Stephen?
I mean, obviously our interview sample was very small, but we did speak to lots of people who reported to us payment timelines that were well over a year.
Yeah.
Just given the mismatch between the speed at which they could pay them off and the total size of the pot they had to pay. And that was sometimes people who'd had lots of fines accumulated, but it was sometimes people like the person that I spoke about originally who just had one very large fine. And there was a pattern which was surprising and does not apparently in line with how things should work, with people not really being engaged with about their means to pay at the point that the fines were being set, but then being asked about their means at the point that repayment rates were being set. And that seemed to contribute to quite long time periods. Obviously, it's difficult for us because we weren't in court. We didn't see exactly what happened, but the way people reported that was quite striking insofar as it didn't seem to be in line with how things ought to be working.
I think it's perhaps worth also just observing that when we do have people in court and we are looking at payment rates, we'll be saying, so, approximately. I mean, the means form used to go into quite a lot of detail about actually what your outgoings were and how much disposable income you had per month and so on. And we, as I say, when we're not actually doing paper means forms now, we do sort of condense that somewhat. But we'll ask people, so what do you think is a realistic amount, that you could pay off per week or per, and people come up with things sometimes and you're thinking, whoa, well, that's a bit of an ask. Are you sure? So yeah. I think some of it is the rabbit in the headlights. I don't really know what I'm offering at this stage. But it's, again, as you say, having that advisor there to actually say, because not everybody, of course, especially for some of these low-level offences, not everybody has a legal representative. If you're talking about a non-imprisonable offence, they're probably not eligible to see the duty solicitor. It's very difficult for people and very intimidating. A courtroom is not an easy place to be in. So I think we do try to sort of gauge, but sometimes it just of course it's just not easy to collect that detailed information.
Yeah. I mean, I think. Sorry.
Yeah. So that did come out in our interviews. People were telling us that they did overstate their ability to pay their fine out of fear of being sent to prison, and that all they cared about in that moment was just to convince the court, yeah, I have the means to pay. I'll worry about how I'll pay it later, just to avoid a prison sentence. So that really matches what we found.
Yeah, and again, I think that's probably the right information not really getting out there to people, because you know the chances of actually being sent to prison for not paying your fine are pretty low. You know, it's got to be willful and persistent, I think, is the official language. You've got to actually say, no, I'm not going to pay this fine, not I've been having, you know, real difficulties trying to, because that wouldn't be reason to send anybody to prison. So yeah, I think it's just a lot of misinformation really out there. And
yeah, I think the emblematic example of that for me was the person whose voice we heard at the beginning. I don't know if he said it in the video, but when we spoke to him, said, you know, because he certainly felt like he was on the cusp of custody, and he said, I would have said £1,000 a week if I thought it would keep me out of prison, because I needed to stay home and look after my kid. And I think that's an example of where, and I haven't really developed this thought, I know we're going to come back to practical solutions in the next phase, that the job of assessing someone's capacity to pay, how much they can pay and how quickly they can pay, is actually like quite a complicated and technical thing. And it's something that requires open communication, something that requires detailed information. And actually, it may be that the courtroom at the point of sentencing is not the right place to take that decision. Magistrates absolutely should be making decisions about sentencing bans and the severity of offences and the mitigating circumstances, but whether those the actual precise details of what should be paid by when should be taken up by someone with more understanding of how to map people's financial circumstances and more understanding of how to offer them the opportunity to, in an unpressured environment, talk through openly. As well as actually, people don't always come to court with that information on hand. They probably should, but they don't. Is it the right place to be making those decisions?
yeah, it's interesting because, of course, as I say, you know, we would support bringing back fines courts where we were actually getting a lot more of this information in court. I mean, what's happening instead of that now is that we have courts fines officers. You know, we say, well, we'll make a collection order, and it's up to the courts fines officer to actually arrange the collection of this. We will set payment rates, but I think we feel that actually the courts fines officers probably don't have the time. There's not enough of them to be able to really explore this either. So sort of our feeling is actually bringing it back into court and allowing us more opportunity to explore people's situation would actually be a better way of doing it. But you know, there's pros and cons.
I certainly felt, you know, we saw courts fines officers taking on this role of, okay, you've been fined, now let's talk about how much you can afford to pay a week, and doing that kind of detailed financial work. But it sort of felt like at that point, some of the biggest decisions had already been made. And it also didn't feel like they were had the skills or the time to do the best job of that. I think I'd agree. Yeah,
and of course, by that stage, you already need to have known the ability to pay to be able to set a fine that's payable within 12 months or thereabouts. So you've sort of missed that chunk out if you're leaving it to a fines officer to do that later on. So.
Okay, that's been really fascinating. I'm aware it's 5 minutes to 2, and we promised to give you some time. Those people who've remained with us before, I'm sure their next meeting's at 2 o'clock. So it just leaves me to say, firstly, thank you to my team. So my team in terms of the research team that have done the work. So Stephen and Lucy in particular, but also Carla in the office, Miranda who's our comms officer, for doing making sure this is all run smoothly and the report looks beautiful. Particular thanks to Michelle and Jenny, who run the Community Advice Service in Highbury Magistrates Court. Again, a thank you to Val and Damon for their contributions today, and just to reiterate our thanks to those of you. I see people like Meg on the chat who've been on the advisory board over the past 12 months. Just a bit of a sad reflection, really. So one of the members of the advisory board, Judy Hultgreen, who was a magistrate, sadly passed away during the course of this project, and I thought it was just worth just honouring her contribution. She was a passionate advocate for giving magistrates more ability to be flexible around this population that she cared about deeply, and we were very sad to hear of her passing earlier in the year. So a sad note, unfortunately, but hopefully the work that we'll do in the next 12 months will live up to some of what Judy wanted us to do. But yeah, so thank you to everyone online who has stayed for this sort of hour and a half. I hope you found it really interesting and really kind of call to action for some of you. Like, if you want to get involved in the work in the next 12 months, we really do want to get into the kind of detail of how do we have a system that helps people, helps magistrates, people working in the system, but also the people coming into the system, pay their fines, or maybe not pay their fines for some certain things. I think one of the things that really struck me about the research was most people we interviewed said, you know what, for the thing I did, fines probably appropriate, but the process often left them going, either I have to pay too much, or the process was so onerous that I'd come out of the back end feeling not fairly treated, and that can't be the outcome that we all are looking for. So hopefully a number of you will help us work through how we can change that system. So thank you from me.